test of reasonable restriction. The restriction on the rights under Article 19(1) can only be imposed by a law and not executive or departmental instructions. The phrase reasonable restrictions in Article 19(6) means that the restrictions imposed on a person in the enjoyment of his right should not be arbitrary or of an excessive nature beyond what is required in the interests of the public. The word reasonable implies intelligent care and deliberation which reason dictates. A law which arbitrarily or excessively invades the right of a person cannot be said to contain the quality of reasonableness, and unless it strikes a proper balance between the right guaranteed in Article 19(1) and the social control in Article 19(6), it must be held to be wanting in that quality. The requirement that a restriction should be reasonable means that it is for the courts to determine whether any restriction is reasonable or not. If the courts are of the opinion that a particular restriction is not reasonable, then it will declare it void. The word reasonable thus widens the scope of judicial review, and the determination by the legislature as to what constitute as reasonable restriction is not final and conclusive but subject to the supervision by the Supreme Court. However, there is no definite or absolute test to judge the reasonableness of a restriction. Each case is to be judged on its own merits. The Supreme Court has laid down the following guidelines for determining the reasonableness of restrictions. 1. It is the courts and not the legislature which has to judge finally whether a restriction is reasonable or not. 2. The term reasonable restriction in Article 19(6) connotes that the limitation imposed on a person in the enjoyment of his right should not be arbitrary or of an excessive nature beyond what is actually required in the interests of the public. The word reasonable implies intelligent care and deliberation, that is, the choice of a course which reason dictates. The expression seeks to strike a balance between the individual rights guaranteed by Article 19 and social control permitted by clauses 2 to 6 of Article 19. Therefore, the restriction must have a reasonable relation with the object which the legislation seeks to achieve and must never exceed it. Legislation which arbitrarily or excessively invades the right cannot be said to contain the quality of reasonableness, and unless it strikes a proper balance between the freedom guaranteed in Article 19 and the special control permitted by Clause 6 of Article 19, it must be wanting in that quality. 3. There is no exact standard or general pattern of reasonableness that can be laid down for all cases. Each case is to be judged on its own merit. The standard varies with the nature of the right infringed, the underlying purpose of the restrictions imposed, the extent and the urgency of the evil sought to be remedied, the disproportion of the imposition, the prevailing condition at the time. These factors have to be taken into consideration for any judicial verdict. 4. The restriction must be reasonable from the substantive as well as procedural standpoint. The court should consider not only the duration and extent of the restriction but also the circumstances under which and the manner in which that imposition has been authorized. 5. A restriction which is imposed for securing the objects and laid down in the directive principles of state policy may be regarded as reasonable restriction. 6. The court must determine the reasonableness of a restriction by objective standard and not by subjective one. In other words, the question is not if the court feels the restriction to be reasonable but where a normal reasonable man would regard the restriction to be reasonable. It is this need of objectivity which prompted the Supreme Court to warn the judges not to be guided by their own economic and social philosophy. It said, in evaluating such elusive factors and forming their own conceptions of what is reasonable in all the circumstances of a given case, it is inevitable that the social philosophy and the scale of values of the judges participating in the decision should play an important part, and the limit to their reference with legislative judgment in such cases can only be dictated by their sense of responsibility and self-restraint and the sobering reflection that the Constitution is meant not only for people of their own way of thinking but for all, and that the majority of the elected representatives of the people have, in authorizing the imposition of the restriction, considered them to be reasonable. 7. A restriction to be reasonable must have a rational relation with the object which the legislature seeks to achieve and must not be in excess of that object. The grounds for which the legislature can impose restriction are mentioned in clauses 2 to 6 of Article 19. 8. It is the reasonableness of the restriction which is to be determined by the court and not the reasonableness of the law. The court has only to see whether the restrictions imposed on citizens' rights are reasonable. The question whether a provision of the Act provides adequate safeguards against the abuse of power given to the executive authority to administer the law is not at all relevant. Mere possibility of the abuse of the power by the executive authority is not test for determining the reasonableness of restriction. 9. Restrictions may also amount to prohibition under certain circumstances. Thus, a law depriving a citizen of his fundamental right may be regarded as reasonable restriction if it prohibits him to carry out dangerous trades such as that of trade in liquor or cultivation of narcotic plants or trafficking in women. The right of every citizen to pursue any lawful trade or business is obviously subject to such reasonable conditions as may be deemed proper by the governing authority of the country essential to the safety, health, peace, decency and morals of the community. But where a restriction reaches the stage of prohibition, special care has to be taken by the court to see that the test of reasonableness is satisfied. Right available to citizens only. The rights granted by Article 19 are available only to citizens and not to an alien or a foreigner. A foreigner is not a citizen of India and therefore he cannot claim a right under Article 19. A corporation or a company cannot claim a right under Article 19 because they are not natural persons. Citizens under Article 19 mean only natural persons and not legal persons, such as corporations or companies. But now there appears to a change in the judicial attitude on this point. In bank nationalization case, AIR 1970, and the newspapers case, AIR 1973, the court has held that though a company cannot claim a right under Article 19, but its shareholder can claim the rights guaranteed by Article 19 if by the state action the rights of the company as well as of the shareholders is impaired. The fundamental rights of shareholders as citizens are not lost when they associate to form a company.